Just to recap the description of the event, the justice system is really meant to be the great equalizer, protecting our rights and upholding the law. But is it truly just for all Americans? In this, tonight I'm going to basically try to talk about, and I did not get to all of the questions that were in the chat, but I will talk a little bit about how judges and justices are appointed. I'll just say it now that they're appointed by politicians, so they are not voted in, and we'll talk about how that we can talk about in the Q&A how that may influence their decisions. We'll also talk about a little bit about dark money and how it could shape judicial rulings. There is a decline in public trust in the courts, and I'm going to talk about some solutions that might help us rebuild them. Um, I'm only going to talk about a couple. I actually have more than I put in the presentation, but I'm going to try to keep it not too long tonight, but we can talk about more in the Q&A. And then I'll talk about some personal stories with the justice system, and where I feel like it fell short, and I'll give you the scenarios. And then I will generalize those with statistics about the justice system that back up that my personal experiences are not anomalies or surprising even compared to what the justice system is generally doing. And
This
I will,
arena doesn't seem to realize how badly booked.
Victoria, you're not on mute, so I just muted you. Um, so um, are basically I'll talk about some potential reforms to make. I'm probably going to have to do this event again because I again didn't have as much time as I would have liked to prepare, but hopefully this will be at least somewhat useful. Um, and um, and with that said, I will go to the next slide. So we talked in about unfair outcomes in our event on DEI and how the justice system doesn't always produce fair outcomes. And so we're going to look at some evidence of that. I'm going to actually give a personal anecdote first. I tried to deposit some money orders into a major bank that rejected them. So I deposited into another major bank, which accepted them, and I thought it was fine. But then they told me months later that my money orders were already deposited in the first bank. And I tried to call them and I tried to talk reason and say, I showed them my bank statements and showing that the money never got deposited. They just said, well, our systems say this and that's what we're going to do. So I ended up suing them in small claims court. I won, but then there was another step in the small claims court that said, well, how much money do are you owed? But I had already said how much money they stole from me. And basically I added my time value of money because I'd spent 10 to 15 hours on the lawsuit. And when I got in front of the judge, he was like, he would stop talking. And so then I would say something, and then he would talk over me and like, get very upset that I was talking over him. And I would apologize because I know judges are very self-confident, is the polite way to put it. But either way, that happened 3 or 4 times, maybe more. And it was just like it couldn't have been a coincidence because he was definitely like seemed like he was finished talking. And then at the end, he just acted frustrated with me, dismissed the case, and I lost $2,600 because the judge just decided to dismiss my case because he acted annoyed with me. Now, I told this story to a friend that's a lawyer, and he said, "Look, Garrett, you're not allowed to ask for the time value of your money in a small claims court case." And so he probably was just giving you a hard time because that's what you did. I would much rather he had said, you can't ask for time value of money, and so you're not going to get this money, but here's what you will get. And that would have been fine. I looked at the appeal process. Well, the appeal process, there was a $2,600 that they stole from me. The appeals process cost $1,300. And I looked up how often people succeed on appeals, and it was nearly never because the judge systems all back each other. So I ended up reporting the judge because I thought he unfairly, and he said just go back to the person that wrote the check, and he doesn't seem to know what a money order is because in a money order, once the money order is written, the person who created the money order doesn't have the money anymore. So I couldn't go back to that person. They didn't have the money at all, and they're not going to give it to me a second time. So the bank had the money and they were just withholding it. So that was an example in a very small case. I'll give some bigger cases later where the justice system was very unfair to me. You know, the time value of my money was worth more than the $2,600 at the end of the day, probably. But um, you know, let's look at some more statistical views. Prosecutorial disparities, basically, research shows that uh, prosecutors are far more likely to seek and secure mandatory minimum sentences against black defendants compared to white individuals charged with similar crimes and having similar criminal histories. Um, from a sentencing perspective, people of color get harsher sentences. Black males receive sentences that are notably longer than for white males convicted of comparable offenses. If you look at people sentenced to 18 months or less, black males received a 6.8% longer sentence than white males. And then we'll talk about it's not just black people versus white people. I have sex-based statistics later on as well. But from a federal sentencing perspective, black defendants get nearly 10% longer prison sentences compared to similarly situated white defendants. So there's definitely some disparity there, even given comparable examples. Now, incarceration rates. 32% of the incarcerated population is black. Only 14% of the US population is black. So, white individuals, 31% are of people of the incarcerated population is white, even though it's 60% of the population. So, about the same incarceration rate, and there are four times as many white people. If you look at the imprisonment rates per 100,000 person, that makes it much easier. There are 901 black people, 434 Hispanic people, and 181 white people per 100,000 imprisonments. Now, black people were admitted to jail more than four times the rate of white people and spent on average 12 days more in jail. Now, you might be thinking, well, this could just be that, let me let me go to the next part. Sorry, I'm jumping ahead of a slide. So sentence lengths, blacks received in 2017 to 21, 13.4% longer sentences than whites, Hispanics 11.2% more. Amongst females, Hispanic females received 27. Um, I'm just going to mute you, Michael, because you had some background noise. Hispanic males received almost 30% longer sentences than white females. Now, it's easy to say, well, that's because minorities commit more crimes. But actually, I went ahead and challenged that assumption because, I didn't know if that was the case or not. And so I try to do what I call looking for reasons I'm wrong rather than reasons I'm right. And really, I was actually channeling what I expected to be pushback on the statistics I gave and trying to explain them. But actually, there have been studies about this, and they looked at the fact that crime rates don't really fully explain the disparities. So even accounting for the criminological insights and looking at specifically situated people, even though they were in specifically or in similar situations, the incarceration rates should technically align for similar situations across different races, but they don't. And so the fact that there's a divergence amongst similar situations and there's still a diversity in outcomes says that there is some sort of systematic, but I think probably unintentional bias, but there is some systematic bias. Now, self-reported, oh, and here's how we know that. They did self-reported crime rates. And basically what they did is they looked at out of the self-reported crime rates across racial, ethnic groups, especially amongst juveniles, the crime rates were actually similar across all demographics. And the evidence actually suggests you might, if you're a skeptic, be saying, well, maybe minorities are more likely to self-report or less likely to self-report, but or rather the other way around. If minorities were um, basically what it comes down to is, and I'm sorry, it's like I said, it's been a long day. So what it comes down to is that by looking at self-reporting, they found that there are no statistical, that there are really statistical problems with the outcomes that ju the justice system is giving to people of color and to men. We'll get into that next. Um, so male defendants receive a 63% longer sentences than female defendants, even when accounting for similar offense in history. 28% of convicted men were incarcerated compared to only 17% of convicted women. So the justice system blames men far more harshly and frequently than women. There are, pros and cons to being male and female in this world. When it comes to the justice system, it's not so good. The criminal justice system, anyway, it's not so good to be male. Before being imprisoned, individuals typically come from significantly poorer economic backgrounds. So there is a socioeconomic aspect to this. And basically, incarcerated men had a median income of about $20,000, while non-incarcerated men have about $41,000. This is before they're incarcerated. Now, the gaps, the gaps between the socioeconomic gaps exist across both racial and gender lines. And this is part of why one of the goals of the FTI, by the way, I didn't post, and I normally post if people want to learn more about the FTI. I post um, a link to help people learn more. Um, let me say, learn more about the FTI. I'm glad that auto corrected me. So basically, one of the goals of the FTI are super ambitious. Our most ambitious goal, perhaps, is to help everyone on Earth make $100,000 USD in purchasing power parity in the average US town. I think that would drastically reduce crime rates if these statistics are right, that poor people are more likely to commit crimes. I would argue that it kind of does make sense. And I couldn't causally confirm this, but it does make sense to me that there would be much lower crime, because it's hard to say whether or not it's causation or correlation about whether poor people commit more crimes. But either way, if you solve the problem of poverty, then and or people being poor in general, I think there would be much less likely the amount of crime that we have today. And I also think it's important to remember that someone making 20,000 a year, looking at, what happens to them when they go to jail, having somewhere to, that feeds them and takes care of them, may not seem as big of a punishment, even though jail is no fun from the people that I know that have been there. Um, but it's less of a punishment to someone who's, barely scraping by and able to feed themselves than it is for someone making, even $40,000 a year. Um, Next, prison not only reflects disadvantage, but it deepens it. So a white individual that's incarcerated loses about $270,000 of earnings in their lifetime, compared to socioeconomically similar peers. And for Black and Latinos, it's actually much larger. It climbs to 360,000 and over $510,000 respectively. And also formerly incarcerated people face very high unemployment, about 27%, and struggle to recover financially. It's much harder to find a job if you are a convicted criminal. I can only say, like, so many times I've had to fill out that form that says, have you committed a crime in the past? And employment requires that, at most companies. And so it must be really difficult to be a person with a criminal record. Um, given an example, a personal example, I went into business with a person that was married and said that the business was going to be in his wife's name for tax purposes only. But when they got divorced, the wife ended up getting the business, and she almost immediately started stealing money from the business. I was only friends with her husband, and obviously they were divorced. So she, while she was nice to my face, was stealing money from the business. When I tried to file a police report for it, and it was a high level of theft, which would have been criminal. At least I believe it would have been, at least my ChatGPT research says it was criminal. But police in two different districts of New York City refused to take even a police report that the money was stolen. I was told by insiders that that was because they don't want to get involved in what they consider a civil case until the civil case is won. But I also was told by insiders that they also want to keep the crime rates down in New York City, and so they don't report all the crimes. So that's a little disconcerting because even though crime rates may look good, they may not be real. Now, another David and Goliath story. That was not a David and Goliath story. Now, another story that is a David and Goliath story. I had a team member that I recruited to my team. I was compensating him with over $1 million a year of equity for working part-time for me. I told him the four things I was going to use to beat my biggest competitor. It turned out that he was actually working for that competitor, and they proceeded to copy not one, not two, not three, but all four of those things, two of which are considered the greatest inventions of that company in its history. I can't say the names. I can just say that I believe that at least three of those things were copied from me. And I know that from information that they made at least $100 million on just one of those four ideas from public press releases that they've issued about those ideas and the amount of money they've made from them. Now, the judge in the case, I finally found someone to sue them on a commission basis because I didn't have a couple $1 million to sue them. And then the judge, after a year, dismissed it, saying that it was a coincidence. And I'm not allowed to make accusations legally, but the Supreme Court has now ruled that campaign donations to judges are legal. And even when it creates the appearance of bias, it's still considered legal. To me, I feel like that would be corruption. And what the Supreme Court would call a tip, I would call a serious conflict of interest. I can't prove any of that happened. Donations to judges aren't even a subject to the Freedom of Information Act, and the only financial implications to judges are self-reported. And I looked up whether or not anyone checks whether those reports are accurate, and there are no checks and balances with them. So there would really be no way to know if any of that happened, even if it did. So that was my personal experience with the justice system. By the way, that would have been 3x damages on the $100 million. On a conservative basis, it would have been a $300 million lawsuit because if they did it knowingly, which I have good reason to believe that I can't share with why, I have good reason to believe that it was done knowingly. So, um, Um, this is so I looked into this as a general rule about whether or not it's common that small businesses face a large disadvantage in civil litigation, and it turns out to be very true because those of us with small businesses have limited budget, and larger firms can put hundreds of thousands or millions of dollars into a lawsuit. Not, I didn't have millions of dollars to put towards a lawsuit like that to get a top-notch lawyer. And uh, the high fixed costs of litigation basically give a huge advantage to people with deep pockets. But if by the way, whether you win or lose the first time, let's suppose, in my case, it was dismissed. Let's suppose that I wanted to appeal it. Well, I only had 30 days to find a good judge, a good lawyer that could appeal it, which would have cost me even more money. And there's no one that's going to take an appeal on commission, so I would have had to put the cash up front, which I didn't have. And so, whereas like, let's suppose that I had won the first time. Well, the company, take another example of another small business that, puts the money in and actually wins the lawsuit. Well, the counterparty who has more money can then appeal the case. They have a large set of lawyers who are what are called appellate lawyers, which means they're the ones that deal with appeals. An appeal says, I don't agree with the lower court's decision. I'm going to bring it up to a higher court. And so if you have more money, you have appellate lawyers at the ready and you can pay them to keep appealing all the way up to the Supreme Court potentially and until they win. And so even if you're a small business that wins the first court case, you're probably not going to get the money as long as the other side thinks that they can just appeal and win by default because you can't even present an argument at the cost level that it would cost to go to an appeals court case. And of course, these courts, when you appeal, are more serious than the lower courts because they get fewer cases, and so it's more expensive to hire appellate lawyers. So, another anecdotal case had an apartment 20 years ago where I had a housemate. We both had cars. Lease came with one spot. I added a rider for the second spot. And a few weeks before my lease was set to renew, the apartment sued me saying that I didn't pay them for the second parking spot. They had never billed me for it because there was already a rider for it. But they had a lawyer on staff that did nothing but sue tenants, I later learned when I was in the court, because one of the other lawyers told me that that's what they do. They just sue all their tenants. And so I obviously moved out of the place, but I went to court twice. They kept dragging it on in court. The court unfortunately played right into their hands, and they're used to doing this, so they know how to do it. And they wouldn't. I ended up having to settle for 50% of the money, which is essentially extortion, in my opinion, because I couldn't take a third day off of work to just challenge this court case for the amount of money that it was dealing with. So another case where unequal money creates unequal outcomes for the justice system in the justice system. So let's look at some solutions. Those that have been here before know I like to propose solutions, and so I hope that we'll agree after what I just presented. There are some problems with the justice system. Let's talk about some potential solutions. The first one that I have is uh, well, the first one is actually a current solution, which is mediation on arbitration. This can require, though, in-person visits. Mediation and arbitration is like a trained specialist that helps try to get the two parties to agree and come to a settlement because court cases are very expensive. And so it tries to get them to come to an agreement. The problem is that mediation arbitration clauses are always in one location, and it's usually in the location of the person who has the most money. And if you don't have the most money, then you have to often fly to the place that the other person is, which means there's another socioeconomic problem where if the case is over $2,000 and it's going to cost you $500 to fly to the other place, well, at that point, is it really even worth flying out there for the suit? Um, and so um, and so it creates this, again, socioeconomic advantage to the wealthy in the justice system. So I've started now in my contracts pushing back on those, and I've not done business with people that I could have made a lot of money for, but I was the smaller entity and they wouldn't change their mediation arbitration rule. So I just said, okay, I'm not going to work with you, and I'm bringing business to two of their competitors. So, there are ways that as an entrepreneur, as a small business, you can fight back. You need to have alternatives, and you need to be perfectly willing to jump on those alternatives and work with the more flexible people. The other two companies have been more flexible. So, um, I have another concept that is kind of, I think, novel because the justice system is very slow and very expensive. Even mediation and arbitration, I would imagine, are still relatively slow and they are reasonably expensive, although not as expensive as court. What I'm proposing is what I call a citizen court, where you could do it remotely. You would get a jury of five peers that are agreeable by both sides of the case. If they can't be agreed on, then it goes to mediation, arbitration, or court. So people have an incentive to agree. And both sides present their argument to the jury. There's no judge, just the jury of peers decides whether or not someone caused significant unnecessary harm. And if they did, then there's a penalty awarded by the jury. Now, anyone can appeal and go to an arbitrator, a mediator, and a formal court if they want to. But I think what this would do is free up the court system from the small cases that, it could have a limit on it if people wanted of five to $10,000. And I've thought about trying to put something like this into my legal contracts, but I don't have the time to work out all the logistics for it right now. But The you could have a legal AI, even though AI does a legal AI to handle legal questions for the jury, so they can ask legal questions, or a resource for the jurors to ask legal questions about what constitutes a legal contract, contractual terms, legal contractual terms, etc. But I would argue that very often, and I would argue in all of the cases that I gave from my personal experience, if you stuck it in front of a jury of five peers, it would have been really obvious that I was in the right, and we wouldn't have had the situation that I ended up in, where I felt like the justice system was unjust. I would literally take any random five Americans and say they would have been more fair than the way the courts treated me in the situations that I was in. Um, and that's how much faith I have in the average American, in spite of the fact that we live in this very divided country. As an independent, I do believe that the average American, across most things, if they're non-political things, is more likely to be fair than the type of situations that I gave that I've experienced. Now I have a better solution, which is the concept of an AI court. And imagine you have an AI, and I could build something like this without a lot of difficulty, quite frankly. And well, the only part that the making sure that it doesn't hallucinate may be something that I have to research. But let's put it this way: both sides feed their evidence into the AI, and then there's a dialogue between both sides and the AI itself, where each person gets to defend themselves, refute the other person's arguments, et cetera, through text, through voice, through images, everything that you would use in a normal court of law. Um, and the AI itself would make a judgment about whether or not anything illegal happened, and if so, what the damages would be. And it would do this, I would argue, it would be more accurate than the citizen courts, most likely, even though I do have faith in the average American. Um, the AI would actually have a better understanding of legal standards, whereas the citizens would need to learn that. This is where I think it would be the fastest and cheapest option, nearly free for the state, and you don't have to choose jurors. Nobody gets inconvenienced. And I think it would be actually better than my original idea of citizens courts. And again, while AIs do hallucinate, there are specialized AIs used in the legal industry that do not hallucinate and can be relied on to have accurate responses. They just probably cost a little more to use, but it's still trivial cost compared to all of the other alternatives here. And so I think this kind of tool could be created with not even a huge amount of funding, quite frankly, in terms of what goes into the amount of money that goes into the legal industry. So that's my vote, is that we should be able to create an AI court. And that's one that, I might be able to actually put that into my legal agreements now that I think of it. And and so that said, I'm gonna leave it up for Q&A. So 34 minutes, we have an hour and a half for Q&A. So just raise your hand, like virtually. Raise your hand if you have questions or comments, and we'll talk. Go ahead, Tim.
Okay, so do we know, I think this is very commonly unknown. The judge is not supposed to be the head of the court, as it were. He's not supposed to make any decisions. He's only supposed to, according to the law of the land, is supposed to be common law. But it's all, the Constitution has been subverted. Um, and the jury was the people made the decision. Okay, so I would ask,
That's true in criminal cases. I think the jury's supposed to make the decision. In civil cases, it is a judge. So if it's
okay,
not a criminal offense, then it goes to the judge. But
you
um,
know,
yeah,
I'm not certain about this. I'm the Constitution, the way they designed it, the jury was supposed to be right. Look, where would there be the checks and balances if we could have a judge, right? If the judge is already corrupt and he's making decisions, as opposed to our own people making the decision, there's the check and balance right there in case a branch of the government, in this case, the judicial branch, becoming corrupt, then we could have the check and balance by ending it, by controlling it with the last step ourselves, the jury, right? Okay, so now in relation to the AI, so I would say respectfully, would you really, that's putting the decision in the hands, that would be putting the decisions in the hands of something that would be other than ourselves.
Well, not
You know what I'm
necessarily. So
saying?
that the AI is actually trained on all of the data about, past trials. So the AI would be knowledgeable of every single lawsuit
Okay,
since the US was founded, and even lawsuits in England on which common law was created. So it wouldn't be on something other than human. It would be on human responses and legal responses
okay,
historically. So it's really just being an objective third party. It's like if you could like vet properly and make sure your judge was very trustworthy and reliable and objective, and knew every single law at the same time, that's what the AI would be like. We can't do that with a human, especially not when we're allowed to donate money, dark money to judges, and when wealthy companies can donate money to dark money to judges. We have no sense that that's going to be fair, right? Like it's hard to have a sense that it's going to be fair, especially when you have situations like what I came to, where they say
okay.
copying not one, not two, but at the time we knew three, and I later learned that the fourth thing was copied too. But even three things, like what's the chance that those were all coincidences? So, it doesn't take a genius to figure out that something is wrong with that picture. And by the way, juries are used in civil cases, just not all the time. They're used sometimes in civil cases. I did not get a jury. I didn't get that far. The case
Yeah,
got.
but the judge is telling them still, he's telling them, he tells them the law that
Yes,
on which they're supposed to decide. They're not even supposed to, the jury is supposed to have all, is to, even as one court case says, can decide in the teeth of the law to even if they're supposed to judge according to a law, they can decide any way they want. They don't
right.
even have to judge. They're supposed to be even above the judge according to the law of the Constitution.
So how
Um,
do you raise your hand here?
So at the bottom, there should be the bottom of your screen. If you mouse over the screen with all of our faces, there should be a raised hand button. If you don't see it, look for it under reactions or under more. And if, by the way, I forgot to say the rules of engagement for this. So if you want to respond to what someone just said, just speak up. Like after they finish, just speak up. Whether it was what I said, what the other person said, like anyone said, just speak up and just keep your comments to less than 20 seconds. If you're responding to someone and you didn't raise your hand, if you want to start a new topic, raise your hand. And for each new topic, keep your new topic introduction to under 2 or 3 minutes. And then responses, though, we can kind of have a fluid conversation with people, keeping it to less than 20 seconds.
Yeah, well, I still don't find any place to raise the hand. I looked under more. I don't find anything there.
Click on react button.
yeah, a
Sure.
word. The heart is, John. I think it's
React button.
where the heart is. See where the heart. Mine has a heart, and then it'll say. I don't know. Mine's all in French, but it might say in English. Raise your hand. There's an image of a
Says
hand
raise
there.
hand.
Yeah, there's an
And
image of
there's a
a
hand.
May
yellow
have
hand there.
put your cursor in the bottom of the screen. Maybe that's another thing. Because then this bottom bar will show up and one of the buttons should be a heart that says react.
Okay, I see react. Yeah.
Great.
So just click that, I guess, huh?
It would be
Again,
react and then raise hand.
I got it. Okay. I'll wait
Yep.
for someone
There
to
you go.
call me.
So Steve is just ahead of you, and then we'll go to you, John.
yeah, hi there. Steve here from San Francisco Bay Area, software development manager. So I guess we were semi-colleagues, Garrett.
Yes.
Um, Yeah, so regarding your small claims court experience, I mean, the solutions you proposed, seems to me, the existing solution of mediation uh, would be preferential to me. The only problem with that is, as you said, it might be expensive. So
Yeah.
why not just fix the expensive part of it? For example, you can have a Zoom meeting in front of the mediator rather than having to show up there for one. So I would certainly prefer that to AI because AI depends a lot. What AI says depends a lot on how it's trained, right? So as you probably know, most AIs will tend to agree with you, right? If you try to debate things with AI, they're gonna kind of come around to your point of view, kind of. You say, but, and then AI says, well, yeah, okay, you are correct, blah, blah. Sometimes it will even apologize. So I guess you can train it to be different if it's a mediator, right? But it
Yeah.
still depends a lot of who trains it, right? And that part is, not clear. That part is
The
hidden
government,
from
the
the
government
users.
would be the one that trains it in my example. So, if you don't trust the government to train the AI, how can you trust the government to run the court case?
Well, at least in the latter case, you're facing the government directly, or in this case, government appointed mediator,
Mm,
before you go to
No,
the
the
end.
mediators are not government appointed. The mediators are
Well, even
through
better.
they're through not for pro like they're through for-profit companies and they cost thousands of dollars a day. So they're not cheap and they're people who are trained in the law, but when it comes to, facing the government, I forgot to mention and I forgot to mention that judges, by the way, even if they're not adjudicating the law correctly, they're very often defended by the legal system, and judges are the profession that are the least likely to ever lose their jobs. It's like I forget the number. We went through it at another event, but it's like the number of federal judges that have been removed from their jobs is like in the very small numbers. Let's put it that way. I don't want to quote because I may not remember. Someone can look it up, but it's really unlikely that judges will ever lose their job, no matter how bad they are at their job. And they're political appointees. So politicians put them into positions of power. So really, who are the judges? The judges are the people who are friendly with politicians. And then they get into that position of power. They have power over all of us in that position, and there's no way to get rid of them if they suck.
Well, I mean, some judges are appointed, right? Some judges are elected, actually. I remember distinctly voting for judges many times over here, even though I wouldn't necessarily know who given judge is, but I could look them up. So
That
I don't know how exactly that
exists.
goes on the low level judges, but I think some are elected, in fact.
Some are elected, you're right.
Garrett,
Yep.
Well, let
when would
me,
you like me to jump in and start addressing some of these legal issues?
Oh, go ahead. Go ahead, Stephen.
I'm
Yeah.
not sure where to begin, but I mean, for one, I mean, there's so many things that I thought of needs to be addressed, and I thought I'd hear people out first, but
You're a
maybe what we
lawyer.
can do
I
is just
sense you're a lawyer.
allow
Stephen,
everyone to raise their questions first and then have a chance for me to respond to some of them
You're a
as a
lawyer,
lawyer
right?
to explain,
is a
yes, I'm a
lawyer.
lawyer.
Yes, Stephen is a lawyer. Can you introduce yourself, Stephen?
Yeah, I
But
can
just so
sense
you
that.
people, sure. And by the way, I want to thank Garrett for inviting me. We met at my brother's surprise birthday party a few weeks ago, and we struck up a conversation, and he invited me to join you guys here tonight. So I appreciate that. And I did want to say that, I appreciate the effort to try to hear each other out. Um, and Garrett, you made a nice presentation, and it's thoughtful. But for me, looking at it as a lawyer, there are a lot of things that are missed that I would have advised you on in making that presentation. Not that I want to criticize it, but that perhaps it could have been framed better or more accurately. There's a lot of things that I could go over with you, but let's start with mediation and arbitration. This is something that I've actually taught and I've practiced. There are several forms of mediation and arbitration. The one that you're thinking of now with regard to small claims court. The small claims court is an abbreviated legal system in itself, and there are different structures so that if it's for a small amount, it gets settled one way, and for a larger amount, it gets settled another way. In any event, when you go to court, you're given an opportunity to go before a mediator, or what's called the court annexed arbitration. And you don't have to agree with the result. You can still go to trial, but if you agree on the result, it's legally binding. Uh, what Garrett's thinking of in some cases is that you have, when you enter into a contract with someone, there's already an arbitration clause or a mediation clause built into the contract.
Right.
Or after a dispute arises, you can enter in an agreement that you're going to settle it through mediation and arbitration. And this has become because it relieves them of their court dockets, fewer cases to decide on. And this was started originally centuries ago with regard to business disputes. They thought, let's refer these cases to people who have expertise in this industry, and they will settle the matter as arbitrators. This bled into other things that, like consumer and employment and other things that it was not intended for, but the courts are not intervening because they don't want to have to weigh in if it's taken off their docket. So far as AI is concerned, and I'm just giving broad brusher, we can start research with AI, but I would not rely on it. I'll give you an example. What we heard is that someone submitted a brief to a judge. The judge checked the brief and found that none of the information in the brief that was generated by AI even existed. It was entirely made up or fabricated, if you will. Whatever people use to do research and to write their briefs and whatever judges rely upon and their clerks rely upon, that has to be checked against primary sources
Yeah,
to figure out what the law really is. We can't just rely on conclusory assertions or what some computer might generate for us. And so there's actually, the process that one has to go through as a lawyer and as a judge. And I worked for a judge.
hmm
Federal judges are appointed. In New York, they are elected at all levels. I think you can get appointed to a higher level in New York, but you have to be elected first at the Supreme Court level. And the Supreme Court is the trial level, and the highest court is the Court of Appeals. New Jersey, it's by appointment at all levels. And so where the campaign money comes in would be is judges are running for election. They can collect money to run their campaigns, but they have to be careful not to say how they would rule in a certain case. When judges are
what do they have
appointed,
to
that could
avoid?
certainly be influenced. I'm sorry, go ahead,
What do
Garen.
they have to avoid, Stephen?
They have to be careful not to say how they would rule in a certain case.
Right, but
And that's true in the confirmation process too. Because if they do, then they're predicting, and then they have to sit out on the case. They have to recuse themselves because it no longer seems fair that this guy has decided how they're going to decide this case without even hearing the facts.
right, but if they
Uh,
do it after the fact, and Stephen, if you don't mind, let's keep it conversational so that it's not just a one
yeah, I'm
direction.
just trying to give you some broad
I
overview.
want you to,
Yeah,
but like
yeah,
I don't want to
yeah.
have it just be one
I don't
direction.
want to overwhelm everybody, but yeah,
And
so
yeah,
I just wanted to give those kind of things as a broad thing to kind of incorporate into what you've given so far. And so if anyone has any questions about that, I'd be happy to answer them. But I think in large part what we need to do is try to lawyers think about these things a little differently than non-lawyers, and I wanted to get that perspective. Thank
yeah,
you.
no, I appreciate that. I will say about the lawyer that used he probably used ChatGPT or some non-legal AI to run that search. At the time that that happened, there were no legal AIs that I was aware of.
Right.
So that's why that happened. But if you use a properly trained AI and a properly functioning AI for the legal profession, that would not have happened and could not happen. So I don't think that's a fair criticism.
Possibly, but I don't think
Yeah.
we're there yet. I work at the New York City Law Department. We are not anywhere near there. We can rely on AI or anything else
I can
to
tell you from
automatically write our briefs. Yeah,
my
yeah,
friends that are lawyers, they use AI for legal research all the time. And they
they can
use
use it for research as long as it's not writing the brief itself.
I have not asked that specific question, but yeah, I will say that AIs are reliable and can give accurate answers. The other thing I would say is that I would argue that in all of the cases that I gave the example of, humans hallucinated in one way, shape, or form because they gave a very poor, decision for a very clear legal situation. And so I would much rather, at this point, given my experiences with the law, I would much rather put my hands in an AI and in five average US citizens than I would in the legal system.
I'm sorry, Sarah, you had a question. I missed it. What is it that you would like me to explain? Sarah, if you can just unmute yourself.
Yeah, oh yeah, you just said they aren't there yet. It was kind of a general statement, and I'm just wondering
I'm just
why
saying
they aren't there yet.
because it's still kind of new for us, at least for the department where I work. Uh, I think lawyers can use AI or automated research tools to start with their research, but we are not ready yet to allow that to just turn it over to an automated system without. We have to be responsible. The lawyers are officers of the court, and we have to be responsible for making sure that the law is correct as we cite it, the case law is correct as we cite it, the facts are correct as we cite it. That's on us. I mean, I can't leave it to something that's generated by AI or ChatGPT or anything else. And what happened was in this instance that we heard about, the judge checked that what was in the brief and none of it was accurate. And that person, that lawyer was reprimanded for doing that. And so our perspective is that we have to check everything before we submit the brief. We're responsible for what's in it. And that's what I mean by we're not there yet where we can just simply turn it over to a tool like AI.
Just to
Right. It would obviously be a process, I
just to
Right.
think,
give to
like
I
a
give
agree that
long
it's a good
process.
place. It could be a good place to start. In fact,
Right.
whenever I do research, I start with Google, and it's usually an AI generated research that gets me started and say, all right, let me check that. It sounds good. And then I can start using it, but I wouldn't do it without checking or anything.
Yeah, and that when you say
That makes
reprimanded,
sense.
the lawyer was disbarred, so he was no longer allowed to practice law because he didn't check his work. The other thing, just to let you know, I did a quick search, and I can give sources for this because at the time that case came up, you couldn't get the sources for what AI was saying, so you didn't have an easy way to fact check it, although you can with legal cases. But a 2025 Thomson Reuters survey found that 74% of legal professionals use AI specifically for legal research, and 63% of lawyers use AI for legal work, which includes research, drafting, and summarizing. So it's very common.
Yeah, I hear you. I don't think I'm there yet to rely on that
Yep.
entirely. We certainly have our own processes that we go through, and it includes collaborative discussions like we're having now amongst lawyers on our team about how to address certain legal issues and how to write it.
Yep.
A question.
Sure.
I have a
Go ahead.
question for Stephen.
Yeah.
So there's lots of suggestions here, but for improving it or making it better. But so my question is, how would those become law or be implemented? What's the process for changing the legal system?
Well, in Garrett's suggestion, for example, and we actually talked about this, you can create your own dispute settlement mechanism. That's perfectly fine. The courts have actually upheld that. And the courts have said that, that according to the Federal Arbitration Act, in fact, it's federal law, you can create your own dispute settlement system if you like. And there are very few reasons for being able to overturn determination based on that settlement mechanism. So Garrett can use that for people who agree to use it. The basis for overturning would be if the panel that decides it knew that the law was one way and they decided to disregard the law entirely and apply a different law, that would be a basis for overturning the decision. There are, other things like not giving one side a chance to articulate their argument at all, and what is fair and what's not. But there are very few reasons for being able to overturn a decision from a dispute panel like what Garrett is anticipating.
The other thing, as far as like solutions, I didn't lay this out in the presentation, but it was on my mind. I just didn't forgot to include it. Is that for judge elections? I don't think that people should be allowed to donate money to judge elections. I think it should be done from public funds, because if you donate money to a judge, there's just no way that that judge could rule objectively for
And
you.
I agree with you. I
Okay.
don't think
So
judges
how
should
it's,
be, I don't think judges should be accepting any campaign donations or I'm not sure how best to run for office if you can't accept donations, except if it's publicly, uh, all publicly defined. Yeah,
Which I think
so
Steve,
since there,
yeah.
since there are vested interest in all that, how would that be changed? I mean, is it even plausible
that has to
given,
go through the legislature of the
yeah,
state. Each state is
okay,
different, and so the state
okay.
legislature would have to change the laws with regard to that. Now, courts also have their own ethics that are written by judges, but they have to be consistent with the law. Judges have court conferences all the time. I've participated in them, and they write the rules for their own courts. So that's sort of a self uh, maintained system. Uh, Judges on the Supreme Court are appointed, nominated by the president and confirmed by the Senate. Uh, they do serve for life, except for in rare cases where they can be removed. But that's very rare. It's the same thing. They have to go through the same removal process as the president does, that to be impeached and then convicted in order to be removed. They can't just be removed by the person they appointed, or a new president can't remove them either. And there's no money that goes directly to any candidate for a federal judgeship, but the money certainly goes to the politicians who are making the decisions who's going to be nominated. And I can talk about that for hours
In fact, there were only
and
15
how
federal
this can be
judges.
the wrong people for the nominations. Yeah.
There have been only 15 federal judges impeached, and only 8 were convicted and removed from office in the last 100 years.
Yeah,
100
it's very,
years.
very, it's very rare. It's
Yeah.
very rare.
So imagine how
Uh,
bad those guys must have been that were
yeah.
actually convicted and
Now,
removed.
there is a process for trying to get a judge to step aside to recuse himself. And there are other times when you can try to, frequently what's most used is to appeal a judge's decision. But that again, like you said, can be very expensive and time consuming.
Yep. Any other thoughts on the presentation, Stephen?
Yeah, there are a number of things we can go over, and I'm happy to go on over that with you one-on-one. I don't want to take up
Sure.
everybody's time. I'd rather be available to field questions and to address things as they come up.
Yeah, no, I appreciate you making yourself available for that. So let's let John Durash go, and then people can feel free to address you with specific questions.
Sure.
Yeah, well, the major problem in the courts is that we've left the Constitution, we left it quite some time ago. Through the Rules Enabling Act of 1934, Congress gave the ability to the United States Supreme Court, ultimately to the Bar Association, to write their own rules. Prior to that, they were under the rules of common law. The rules of common law is common sense. That is the key to common law. Common law is just common sense, working from the heart, making decisions in a just fashion. And of course, the jury needs to be schooled on that because they haven't been schooled in school on that. I mean, every child should be educated on jury, grand jury, trial jury. They should be educated on the common law itself. They should be educated on the Constitution. And whenever any child comes out of school after 12 years, they should be able to run their own court cases. They should have enough information to be able to take care of the business, because due process is quite easy. You could teach a child due process in a course of a year. You could teach a child due process. That's simple. The rest is morality, common sense, with an eye on restitution and justice, and that is the key. But what happened was, of course, this goes all the way back to 1750 when we were colonists, and Britain, the king was trying to destroy the courts here in the United States. Well, we weren't in the United States yet. We were still the colonies, but we were running under common law. And of course, the Constitution our founding fathers made it clear that we're under common law, under Article 3, Section 2 of the Constitution, where it says that we're under law and equity. That is it. Civil law is not permitted. But what happened was through the Rules Enabling Act of 1934, the United States Supreme Court came up with the rules, and the rules that came out in 1938. And that threw out the common law. In Rule 2, I believe, or maybe it was Rule 1, but I think it was Rule 2, it combined, the United States Supreme Court said that it combined law and equity under the name of civil law. And therein is the problem. You see, we're not supposed to be under the laws of men. We're under the laws of God. And it was Samuel Adams that said, the natural liberty of man is to be free from any superior power on earth, and not to be under the will or legislative authority of man, but only to have the law of nature for his rule. So that's the key, is we have to return back to the Constitution. And it's a big problem because, you have a lot of bar attorneys that have been taught in school, the civil law. They believe that we're under Roman law. Roman law is just, comes from Justinian law, and Justinian law is just repackaged Babylonian law, which is the law of the city that puts us under the thumb of some ruler, and we become the slaves in the city. And this is the problem with our court system.
Yeah, if I may address a couple of things with what he just said. First, I want
Yeah,
to.
is that okay, John? Go
Is
ahead.
that okay, John?
Sure, sure.
Yeah, sure. Okay. Common law is not common sense. Common law comes from decisions from courts over the years. And so civil law, when you're thinking about the distinction between common law and civil law, each country has their own system. And so we come from a common law system. Louisiana is the exception. They have a civil law system, as is true throughout most of Europe and other parts of the world. But when you're talking about combining civil and equity cases, what they were doing is they used to have separate law courts and separate equity courts, and they combined the two so they can hear all sides of a single case together. So I just wanted to clear up that there might have been a little misunderstanding there.
I understand that lawyers are taught common law is decisions of trial courts. I mean, trial courts are all over the place. You could take a trial court and decision to try to use that as common law in any kind of a case, number one. And when you use that particular case, you could probably find 3, 4, 5, even a dozen cases in order to show or make. Can I finish?
Yeah, someone's interrupting.
I don't
Sorry, I
think
don't
he
know who that
realizes
is.
he's not on mute, so I just muted Gabriel.
Yeah.
Okay, anyway, you could easily find 5, 6, 7, 10 different cases, a dozen cases, if you really search it out, and that will support your case. And the other side will do the same thing. And it really gets down to really confusion is what it gets down to, because that's not common law. That's called comity, comity, where they take these court decisions on the trial level, again, which is only a suggestion ultimately because it's appealable. The appellate court holds some power, and then of course the Supreme Court at the end of the day, if you're on the federal level, that is, in the United States Supreme Court. And but what less than 2%, maybe even less than 1% of the cases that file for a case to go to the Supreme Court really gets heard. And so a lot of cases, there's a lot of really strong and powerful and important cases that you just can't get to the Supreme Court. The problem is this: equity is legislative law. And equity is for those people who operate in commercial activity. They have to operate under certain rules, statutes, regulations, and so on. And government agencies, anybody working for a government agency, they're under equity. They're controlled by equity. And they could be tried by judges as long as it is not criminal. Once it becomes criminal, it moves into a common law court. Now, it is true that the statutes that control them or the regulations that control them can be brought into that common law court because they agreed to that when they took the job to work for a government agency or to operate in some kind of a commercial activity. And so they agreed to that. It could be used, but the power and the authority of the people, they can abrogate those things. They can nullify it. They can say, we don't like that law. The other thing is when you're under common law, the judge can't make any decisions at all. None at all. They're there as a traffic cop to keep things moving. They can't, and one of the big problems with the rules is they'll come out and say, you can't use that evidence in this court. They'll shut you down on evidence. And I've seen it done a lot of times. You know, I don't know how many people are familiar with the Bundy case out west. And you have the Hammonds up towards, I think it was Oregon. Those cases were pretty, well known. It was back, I think it was maybe 2017 or something like that. I don't remember what year it was in. But those cases there, they were shut down. I found out that all juries, and I've been involved in this for quite some time now, all juries really are stacked juries, because they have, if you go into the federal system and you look up the book, you get a hold of the book, which is
Try to finish your
the
thoughts, Sean.
information for the jurist to be able to, ask questions, the questionnaire for the jurist. If you read through that, you'll find out it stacks the jury. They ask you, what news do you listen to? CBS, ABC, NBC? Do you read the New York Times? Do you have a weapon? Do you have a license to carry a weapon? Anybody else in the family or household has a weapon? They ask all kinds of questions. And with those questions, they can figure out who they want to put on to what case. I have seen so many cases where people are innocent. There's no doubt about it,
Try to
but they
finish your
won't
thoughts.
allow the evidence and they stack the jury. And it's a problem. And we can fix that. But I guess we'll talk about that another time or a little later.
Let me just try to address a few things. One, I'm not even sure where to begin, but comity is not common law. Comity is what other jurisdictions extend to the rulings in another jurisdiction. They recognize it even though they may not have the obligation to do so. That's COMITY. So Canada and the United States may not have an agreement to enforce each other's judgments, but through the rule of comity, they may. There's so many things that
There's
you
another
brought
one.
up
He
here. I'm
said
not even sure
judges don't.
where else to go, but
Stephen, he said that judges
yeah.
don't make decisions in common law, but I think it's the opposite
That
of
is
that.
actually that is not true at all.
Yeah.
And common law is not based on statute, it's based on rulings. So again, that's a misunderstanding that if a judge doesn't have a statute to follow, all right, here's what you do. You look at the Constitution, you look to see if there's an applicable statute, you look to see whether there are cases that are interpreting that statute to particular cases, and you try to follow that. That is the legal reasoning that judges use.
David, may I interject something?
Sure.
That is correct. The judge, I can even show you in various legal books where it says the jury has the power over the judge.
Well, the jury is a
can
fact.
decide the law in the teeth of
No,
whatever the law is.
The jury never decides the law. It is always the
Yeah,
judge.
because they corrupted the system now. It's not under the Constitution. Under the Constitution,
the
jury is above the judge. Just like he's saying that the judge is only an arbitrator.
Tim, the
Go
jury
ahead.
is not above. I'm sorry. The jury is not above the judge. They can't say to the judge, "You're wrong on the law."
How would we have a check and a balance then? If the judge became corrupt,
Because
then
the
there would be
jury
no
is the fact decider, and they have to follow the instructions of the judge on the law.
The jury could check the judge then if the judge became corrupt. If we have the judge on top, there could be no check and balance for the
judge. That's not going to be done by a jury. The jury is not going to nullify a judge's rulings on the law because someone thinks he's corrupt. The jurors are not above the judge in any circumstance.
In the Constitution,
they are instructed by the judge as to what the law is.
I'm sorry, man. Yeah. In the Constitution, they are.
So Tim, I'm going to ask you to cite your reference in the Constitution where it says that, and let's move on to the next.
No, I'm sorry, Tim, but I don't think that's true. But I mean, I'm
cite your reference to the Constitution, Tim.
Yeah, I can even read for you right now. I just to prepare for this. I have a web page open where they talk about the power of the jury.
Okay.
But I don't.
All right, but here, let me just say this. I appreciate that you're trying to draw on a legal document like the Constitution and interpret it for whatever it is that you want it to say. But that's not what judges do.
I'm not interpreting anything. I read literally from the legal books, and it
The judge
said
and
that they
both,
have
all right,
they
and then
can
both can
decide
have
Guys,
their own
guys,
opinion
guys,
about
hold
things,
on,
but it
hold on,
doesn't
hold
mean
on,
they're
hold on, hold
right.
on. Let
All
me
right,
let me
so,
just
right,
say,
but
Tim,
all
hold
right,
on,
there are
Stephen,
different ways
Stephen, just
that Lord, I'm sorry, go ahead.
give
Go
me
ahead,
one second,
Garrett.
Stephen. Tim, please type and put into the chat where in the Constitution you believe it says the jury is above
okay,
the judge. Because
okay,
that's going to be how we get to this.
okay,
Don't speak
there's
it,
it,
type it,
it,
type it. Let's move on to the next thing, and we'll come back
right.
to
okay.
it once it's typed out, and we can look at it objectively at what you think says that.
And by the
Okay.
way, I'm glad that you're asking to do that because what we as lawyers do is we actually look to what is written. We actually look at the law, the Constitution, the language of it. We look at the evidence that has been adduced during a trial. We don't say, well, I like this set of facts, so I'm going to agree on that and set aside everything else. Or I think the law should be this. I think the law was corruptly made, so I'm going to disregard it. We lawyers and judges have to follow the law as it is. We can't just interpret it in a way that we'd like it to be if we were the legislature in the first instance. And so that these are rules that we have to follow. We can't just simply say, you know what, the jury is above the judge and we can disregard whatever the judge says because it's simply not true. We're not allowed to do
Stephen,
that. Nobody is
let
allowed to do
let's let
that.
Tim write
Right.
his thing. I think the
Right.
part about common sense, Stephen, if I can channel what John was saying, and John, you can tell me if I misunderstood this, but in common law, there's the concept of a reasonable person. And in general, and you can tell me if I'm wrong about this, Stephen, my understanding is in common law, as long as you do what a reasonable person would do, you're generally okay for the most part.
That is when you're talking about a duty of care, and it's usually a standard of what would the reasonable person do in a similar circumstance. That's the reasonable person standard. That's a negligence standard.
Is it not used anywhere else?
Well, of course, what we want to do is use reason to reach our decisions. But when you're saying reasonable person, that's a duty of care definition.
Well, I'd like to give a couple of places where the Supreme Court has ruled clearly concerning the common law, in particular, the power and the authority of
Mhm.
the juries. Because look at, you can't, first of all, you can't get an indictment on an individual in any way, shape, or form without the will of the people. The people have to be requested. You have to ask the people, can we have an indictment? Here's the evidence. And the people decide yay or nay. And no judge has any power authority over that. It's the same thing with a jury. And unfortunately, judges are lawyers, and they were taught in bar school. And this whole thing has been distorted for quite some time, at least since 1934. And it goes back even further than that. It goes all the way back to 1750 when the king tried to destroy the common law in the land because it caused a problem for the king. Benjamin Franklin was a thorn in the side. They wanted to shut him down. But no jury would convict anyone that was going up against Britain here in the colonies during that time period. When our
Mhm.
founding fathers put together, they were very clear. And if you go into Bovier's or you go into Black's law, you'll discover that common law is that which proceeds. I mean, the law is that which proceeds according to the common law.
Mhm.
Now, we have John Jay, first Chief Justice of the United States Supreme Court in
John,
1789. He
I do
said,
want to move on to other people that have had their hands up for a long time because we've been
well,
on your
I
topic.
got three short quotes. They're in one sentence each, if I could,
Mhm.
just to
Go
finish
ahead,
it off.
and then
The
let's move
jury
on.
has the right to judge both the law as well as the facts concerning the controversy. That's John Jay, first Chief Justice. Samuel Chase, the U.S. Supreme Court Justice, 1796, said the jury has the right to determine both law and the facts. Okay. Also, Oliver Wendell Holmes, U.S. Supreme Court Justice, 1902, said the jury has the power to bring in the verdict in the teeth of both the law and the facts. And this goes on. They also have the authority and the right. They should be the ones to decide what the judgment against that individual is. How is it that we give an individual who is working for us, we're the master, they are the servant, but they treat us like the servant and they claim to be the master and they make the decisions? How do we put ourselves underneath underneath a servant? It's the clay trying to take control of the potter. That's backwards. It doesn't make any sense. You can't trust the government. Our founding fathers were absolutely crystal clear about that. Washington had a lot to say about that. But I'll hold off because someone else wants to talk.
Yeah, and I appreciate what you just said, but to clarify what they were saying is, yeah, the judge instructs the jury on the law, and the jury comes up with the determinations of fact, and they apply it to the law, and they reach their verdict. But they don't make up the law. It's not like they can disregard what the judge tells them the law is. And so they're not above the law or the judge.
No, they can. I just read a quote from one of our founding fathers just a little while ago concerning that said we're not to be underneath the thumb of legislators. Look, at civil law
Then your
comes from
legal system is
Babylon.
just going to be
Keep
whatever. A
on, just dial up
handful of
forever.
people
Can we
decide the
hear
law
from
should be on that
the
day.
hands, please?
That doesn't
Hear
work
from
at
the
all.
hands.
And that's
This
not
goes
what it
on
was meant to
forever,
be.
this back and forth.
Yeah, let's go on to the
Yeah.
next. Let's go on to the next
Yeah.
person. Paul C. Go ahead.
Thank you. Okay, so I've got a long history in law. I'm not a lawyer, but I'm married to a lawyer.
God bless you.
I think I'm kind of an expert in translating between lawyers and non-lawyers. So let me take a crack at this, okay? There seems to be a big misconception about common law. There's a movement in this country called the sovereign citizen movement, and they believe in this, but it's not substantiated by our legal system. There's no judges that rule that any of this is correct. The common law would be completely unworkable in this country. We go by statutory law, which gives Congress, which gives the federal Congress and state Congress and lawmakers the ability to create laws, which the judge will apply in a court case, and the jury will determine whether or not the law was broken or not. They're the fact finders in the case. There's one exception to what Mr. DeLuca said, and that is something called jury nullification, which is legal and does happen, and that's where a jury will override the judge. It's very rare, and judges don't like to talk about it, and it's kind of a hush-hush thing, but it does happen. It's very rare. It's not common, and in that case, a jury might override the judge on law, but yeah, it's in typical. That's not done.
That's correct,
So you're
Paul. You're right. They could nullify the judge's instructions, right?
What's that?
You're saying man's law is better than God's law because common law is God's law.
I'm saying we're a secular country, so what God's law isn't
Well,
really
we are not
taken into
we are a
consideration.
Christian country.
Okay, well, our legal system's not based on God's law. So let me finish my points. Let me finish my points, okay?
Can Paul
Please.
finish? Yeah.
Yeah. All right. So I've been on 2 juries. One was a machete murder trial in Contra Costa County, California, and the other one was a spousal abuse trial in Alameda County. I have no faith whatsoever in juries. I think juries cannot interpret the law because they haven't the slightest idea what the law is. They need the judge to interpret the law for them because they have no experience. In my machete murder case, there was first, second, and manslaughter at question, each with and without a torture rider to make it a more severe case. I wasn't the foreman, but out of a jury of 12, when we got to deliberations, we had 6 different verdicts in the first vote. Jurors are just lay people. They have no idea how to apply the law in these cases. So they take it from the judge, and even then, they're not very capable in determining the outcome of a trial. So much stuff here. There was a complaint that the jurors are kicked off juries for arbitrary reasons. Well, this is the arena system we have with trials. You have one attorney for the prosecution, one attorney for the defense, and they both can knock jurors off. They both can knock off jurors for cause, or they can just do a preemptive kick them off.
Peremptory challenge.
Yeah, yeah. And so it's combat, right? So they both can represent their side, and they can kick off jurors that way. I guess I'll stop here, but I wanted to go back to the original presentation, Garrett, if you want to give me just one more second.
Sure, go ahead.
I take issue with the systemic bias you had, the racial bias. I do appreciate you put the huge discrepancy between men and women in your presentation. The discrepancy between, say, black and white is only 13%, which I agree there shouldn't be any discrepancy, but there may be many factors involved in that. The discrepancy between men and women is 65% or 63%. So that's a massive discrepancy. But I want to address specifically the evidence that you found that there's systemic bias. I didn't find that evidence compelling. I don't remember exactly what you presented. One of them was a self-reported survey. I tend to disregard those in most cases. And I forget what the other piece of evidence was, but I think there's the opposite. I think lately, especially in the last 10 years or so, there's bias towards more lenient sentences for Black and other minorities. And there's
What makes
evidence for
you
that
believe
too.
that?
What's that?
What makes you believe that?
Because of the evidence that the culture that many criminals, many Black criminals have is so obvious anti-police, so obviously pro-crime. You have cases like in my town where 80 people, 80 friends, family, you name it, conspired to raid a Nordstrom store. There are no cases, and believe me, I've checked, of any other race doing this ever. Okay, you've never had a giant mob of white, Hispanic, Asian people raid a Nordstrom's without a single person. Imagine 80 of your friends and not a single person calling the police. I think
I think
there
that
is.
there
It's
was
not
actually
race. What's that? It's not.
there was a case where a giant mob of mostly white men raided the Capitol on January 6th.
Okay, but that's political. That's a different animal
I
completely.
mean, look, if you're gonna take anecdotes, I'm gonna take an anecdote too. All I'm saying is you don't have statistical evidence. What I presented was statistical evidence that showed that even though self-reported crimes were roughly equal across different races and sexes, the rate at which people are prosecuted is much higher for minorities and much higher for men.
Yeah,
So
but I think, Garrett,
yeah,
what Paul was saying is that there are other reasons that could account for that disparity as well. And and I agree with you also, these things like they could be anecdotal. That doesn't necessarily mean they are evidence or apply across the board, but they are examples of when it can happen. But yes, Paul, I appreciate your input on that. Thank
I'd
you.
like to bring up some of the founding documents concerning the law and concerning, how things operate. We go into the Declaration of Independence, for instance. The Declaration of Independence is a covenant with God that we, the people, made, asking to live under his law, under the laws of
John,
nature and of nature's
you're
God.
going
It's
on a
not the
different.
basis of American law.
Well, if you're not going to let
No,
me build the case, then you won't have the
No, it
information
can't.
that
The
you need.
Declaration of
it's
Sure it
Independence
is.
had a
Sure it is.
specific purpose,
If you
which had
go
nothing to
into
do with the law,
But if you
Mr.
go into, then I was going to take you into the Constitution from there in the preamble.
So,
We, the people,
John, do
ordained and
me a favor.
established.
John, do me a
okay.
favor and write the part of the Constitution that you believe says that it is from God.
Well,
If you
first
could
of all, I don't know
quote
where to write it. It's going to take too
in
long to
the
type it
chat, like
out.
Yeah,
at the bottom
Yeah,
but
there.
but it's going to take too long to type it out
yeah,
because
but
Okay,
as
copy.
I've
Paul
got
was
also, you
saying
got
that,
Lysander Spooner,
You
you
can
yeah,
got,
find digital copies of the Constitution on the internet very easily. So just copy and paste it into the chat.
Anton
yeah.
Scalia, who made a big thing on the jury.
So that said, I want to go to the next question. So Steve Peterman's been waiting
You
very
got Lysander
Yeah,
Spooner, who
he's
made a
been
big
very
thing on.
patient. Sorry, Steve.
Okay.
Go ahead.
As I understand it, most developed countries around the world have in their system loser pays. I'm not sure if that's true, but that's what I understand. So I have two questions. Would that be salutary for our system if that was enacted? And secondly, how would it be enacted?
Well,
That's it.
actually, that's a good point, Steve, because in some jurisdictions, like civil law jurisdictions, the losing party often has to pay the other side's attorney fees. And that's meant to rein in all this outrageous litigation. It's also something that can be incorporated in a statute. In the American system, some laws allow you to collect attorney's fees when you're the prevailing party, and you're allowed to collect treble damages. For example, if you're in a RICO case, racketeering case, if you are able to prove the underlying case, you can get treble your damages and your attorney's fees back, but that's by statute. Often in the common law, you don't get your attorney's fees back unless it's somewhere else provided for, either in statute or in your contract. And so but that's something can be ameliorated or changed if you impose that as a statutory requirement.
It does have another socioeconomic challenge in that one party can afford to pay those fees more than the other. And so if you're
Yes.
the poorer party, you don't even want to take the risk at suing, even if you're in the right, because the other person's going to have much more expensive lawyers. And if you
Right.
lose, you're going to be screwed because you're going to have to pay those very expensive legal fees.
And there's one area of the law that is quite unusual, and that is in the 70s, they started allowing um, wives to get relief called pendente lite relief, which allowed them to get money to hire their own attorneys, because otherwise they wouldn't be able to afford the legal system at all. And so that started in the 70s and early 80s. That is not something that has been incorporated in any other area of the law, to my knowledge. But that's one way of ameliorating that too.
Cool. Thanks. Um, and by the way, I usually do opt in to try to have legal fees get paid for by the loser of
Prevailing party.
the lawsuit.
Oh,
Because
to be paid by the losing party. Yeah. Yeah.
yeah, I do think it's more fair, and even although with my experiences with the court, maybe I should be less less trusting that the court is going to be fair, but I still have
Right.
faith that ultimately that it will be fair more often than it has been for me.
Right.
Devin, go ahead.
Dr. Stevens, I do want to kind of get your more opinion on behalf of AI and why it's not why we shouldn't use it. I agree with you. I don't feel like it should be used because it's really unreliable. But if you can kind of explain a little bit more on behalf of that.
Sure. I think it's a useful tool like anything else to start from, but we shouldn't entirely trust it. And yeah, I think as we grow with AI, we can become more trustful of it. But we as lawyers and judges are trained to first look to the primary sources of what the law is, and then the case law, and develop our legal arguments that way. And then also looking at the evidence that has been adduced at the time of trial or arbitration or whatever it is. And that is a carefully thought out process. AI can help with that. It's a useful tool, but I wouldn't rely on it entirely, at least not yet. I don't think, and what Garrett is telling me is that they've come a long way with AI in law. At least the people that I work with in the New York City Law Department, we're not ready to do that yet. And I don't think the judges would be uh, too happy with us simply relying on AI to write our briefs if we weren't checking before we filed them. So that's our job as officers of the court. We have to make sure that whatever is filed with the court, that it's checked, that it's accurate, that it's right. So again, Devin, it's a useful starting tool, but I wouldn't just rely upon it entirely.
And by the way that I was proposing it is it would be the first step in a dispute, not the final step, right? You could very easily decide that you want
Mhm.
to go to the next level and go to arbitration, and either side could easily step up to arbitration if they felt like the AI was unfair. But I also
Right.
think it would be very interesting to see what the ultimate decision was that was made by cases decided by AI and how accurate it was
Mhm.
through forensic analysis type of thing.
I think that's a good starting point, actually. And so they can see, what does AI recommend? It's not necessarily binding unless the parties agree to it being
Exactly.
binding. And that's essentially what you have now with the court annex process of arbitration, where an arbitrator assigned by the court makes a recommendation. And this happens in a number of situations, like marital disputes. You have to see a panel of three experienced lawyers in the field, and they make recommendations. But you can still go to the judge and have a trial, or you can settle. And so these are options, and they can be helpful, useful tools.
Yeah, absolutely. Anyone else have questions, comments?
I appreciate Bart saying I appreciate his stance, although I disagree with him. That's great. I think that this is a good forum to disagree with one another. I feel that it's been largely constructive, and I've tried to be informative and educational at where I disagree. And so I hope I've been helpful.
Yeah, even as a Canadian, I found this very constructive and informative, and I really appreciate a lot of different thoughts coming in and helping, yeah, broaden, shed some light on like most of us are not lawyers, and so the
Yeah.
law is complex. So it's this was great, and thank you for everyone who weighed in.
Let me put it this way. I think I told Garrett this a few weeks ago. In our first day of law school, we're made to read a book called The Bramble Bush, and it's meant like it's used to scrape out our eyes and we can't see. And then we're taught to start thinking things differently than normal people do. And so we start from that basis and we have to think like lawyers do. And we don't think like ordinary people do. And that's why it may be hard for people not trained in the law. It took me 3 years to be able to take the bar exam. And, in New York, only 6 out of 10 passed the bar exam, even after going to law school. It's not that easy. And I can tell you, too, that judges disagree with one another on what the law is. And I completely agree with Garrett. I've had my own experiences where, in my experience, judges don't follow the law. They do what they want to do. And the system can be very complex. Even when I'm handling my own landlord-tenant dispute or collection dispute, I know that the court is getting it wrong, and the judge eventually affirms that I've been doing it right and they're doing it wrong. But it still holds up the system for 6 or 9 months, and you still don't get the money that you're entitled to. And it can be very frustrating. I've seen that happen with judges too, where they this completely just disregard the law and do what they want to do. There seems to be no remedy, and the appellate system doesn't work for most people either. So from that basis, I agree with Karen and agree that I want to participate in this because there's so much room to make this better. It doesn't work for lawyers very well. It doesn't, who it serves, and has this right. It serves those who have the money who can drag out the legal process.
Yeah.
And I see that happen all the time. Like I said, I work for the city of New York. I've worked on complex litigation matters that have dragged on for 14 years. And, that doesn't serve anybody but the lawyers. And that's too bad. I mean, it's nice that I'm making a living from it, but that's not what I think. That's not what I got into the law to do. It doesn't serve anybody to do that. And in the end, people just give up and they end up resorting to self-help. And we don't want to do that either. We want a system that is fair and predictable. And unfortunately, the system does not work very well right now.
Yeah, that's why I think the AI would be fair and predictable. And the Constitution says we should get a just and speedy trial. Now, I think that's for criminal law, but I would argue
That is for criminal, yes, but
I
it
would
could
argue
also
we
have
should
a
get
in
it for
civil
civil as well,
process
though.
too.
So
Yeah. So just civil is versus penal, criminal. So penal is where by statute you're being prosecuted for committing a crime. Civil is where things are being done between private persons. It could be the government too, but it's not a penalty thing. But yes, it's a good starting point. And I think that at least it'll give a foundation for people to start from. If they disagree, they can disagree, but at least
exactly.
they'll have a basis to start from.
Yeah. And I think if it was found to be very accurate, then
We can build from that.
people would be less likely to go to the next level, right? If they knew that it's going to cost them a lot of money and they're probably going to lose anyway, then the losers would
Right.
be less likely to appeal if there were statistics tracked on how accurate the AI decisions were.
Yeah.
So
So
what
good
other questions?
proposal, good starting point.
Yeah, what other questions do people have? All right, well, we might just end early. Like I said, I've had a long day, so I don't mind ending early. So, um, yeah, I want to thank everybody for your
Okay, I,
comments.
I,
Yeah,
I
go ahead,
have,
Tim.
I suppose, before it's abruptly discontinued here, was asked that I
Oh, did you
implicitly,
put the quote?
im, yeah, implicitly, how can we say relieve the clashing that was going on? So I put it up in the, I don't know whether we know to what I'm alluding. So I put that up in the chat where it says explicitly where you know what was being said earlier about the jury versus the judge.
Right.
There's a court case, and the case is
Corning v. District of Columbia. Is that what you posted? Is that what you, Tim?
Yeah, that's it right there.
I'd have to look that up, but
Okay.
That's from a little more than a century ago. But I can look it up. Appreciate
Okay.
it. But and just so you know, Tim, this is what lawyers do with each other every day. We look up cases, we read them, we may disagree about them, but we have discussions about them. And I appreciate you bringing it up. It's a helpful way of trying to clarify things, and that's what we do every day.
Okay, but it was asked. It was asked to just put it up there just because there was some clashing going on, right? And I suppose it was probably better to try to find some way to
Right, you were
resolve the
citing the
clashing.
case for the proposition that you were saying that the jury. Well, say again what you think it stands for.
Yeah. Again, it's not what I think. It's exactly what I read there. It says that the jury is the way it's supposed to be is that the judge is just an arbiter. He doesn't decide what the law is going to be. He is, and that's what that course case says. And they can decide if he does. He can make suggestions, but they can decide whatever they want in the teeth. Their words are in the teeth of the law. They can decide any way they want. The jury, and it must not be this way, because otherwise, right? We have the checks and the balances. We need this fourth check and balance, or otherwise, then the judicial wouldn't have a balance. And in this way, the jury can be the check and balance against the judicial, so the judicial wouldn't take on become too powerful. You see the point here.
Okay, let me
a check and balance against it.
Let me say this, and this is an AI overview that the court said that that a pawnbroker's conviction for violating a DC statute by operating without a license and charging excessive interest.
Oh, yeah.
The case is notable for the court holding that where there are undisputed facts establishing guilt, a judge can instruct a jury that it is their duty to convict, even if it amounts to a directed verdict. All right, so I don't see anywhere where it says that
but that's not
jury
what it
can
says.
disregard what
it's doing a lot of
ruling.
The AI is doing a lot of paraphrasing there or something. It's the words.
Right.
The words are more.
So let me
more detailed.
And I'm going through
more detailed than that.
And what we would normally do, and this actually would take quite some time, is actually go through the decision itself and talk about it. But I was again just providing the synopsis is that the court is saying that where there's no disputed facts with regard to guilt, the judge can instruct the jury that it has to convict. That's the law. They can't ignore the law and the facts and say that they can choose to say that he's not guilty.
That's what it says. It says the jury may decide in the teeth of the law. It says that word. It says that word for word, verbatim.
I'd have to look up the exact one. This is why AI may be inaccurate and unreliable, because I'm reading one thing and you're reading something else. And we actually have to look at the language of the case itself to see what it actually ruled. And so, but again, this is a process that we go to. So I'm looking at the head notes. If the defendant suffered any wrong from the manner in which it was given, it was purely formal, since there could no doubt his guilt in the facts, and the error, if any, was cured. That's the ruling. That's what it held. When in a criminal case, if this is from the head notes, it's not AI. When undisputed facts clearly establish the offense charge, the judge may say so to the jury, telling them that there is no issue of fact for their determination, and instruct them that while they cannot be constrained to return a verdict of guilty, it is their duty to do so under their obligation as jurors. So, in other words, you can't disregard the law. You can't make up the law. If the facts are undisputed and the law says it has that under the facts, then that statute is violated. They have to be instructed to return a verdict of guilty. That's how I read that. I don't read it the way you read it. And this is what lawyers do every day. This is what judges do every day. We go through this language. And this is just one case, which was 1 page long that I had to read. I've written decisions for a judge that was, I don't know, 70 or 80 pages long. There are briefs that are longer than that because you have to go through the statutes, the case law, the facts that do the trial, and you have to come up with a reasoned decision. And lawyers argue about these things every day. This is what we do. And so there is not necessarily any clear-cut direction on which to go, which is why I don't think you can entirely remove the human aspect, and which is why I think you're always going to have a party that's not going to be happy.
By the way, my understanding in this case is that the defendant was clearly guilty. He was just arguing technicalities to try to get himself off the hook.
Right,
And the
right,
judge was just saying, look, you as the jury could disagree with me. You have the power to do that, but you shouldn't because the guy's guilty. The facts say he's guilty. Everything says he's guilty. And the jury said he's guilty, and that was what stood.
right,
I think you guys may not be disagreeing as much as you think. I think that the court like the laws are complicated. I think we can all agree there are so many laws that it's just not always obvious what is the law in a specific situation. The judge
right.
is there to say what is the law in a specific situation. The jury is
Correct.
there to be the decision maker. So ultimately, like you're both right. Stephen is right that the judge decides, like interprets the law. They're an interpreter of the law. They don't write the laws.
Right,
Congress writes the laws. The judge interprets the laws and then explains them to the jury. The jury is the decision maker about the outcome of the trial. So
that's
in
correct.
the
That's
judge
correct.
is
Right.
more important in determining what is and is not the law, but the jury is more important in that they get the final say and they're allowed to disagree with the judge. So I don't think either of you actually were. I
Right.
think
And so what can
saying
happen too, though, is that a judge can be asked to give what's called a directed verdict if the judge feels on the law the jury disregarded the law. So that's another aspect too. And what
Uh,
this also brings
what
up
is a
is
directed verdict?
a
What is
directed
that?
verdict is where, notwithstanding the decision of the jury, the judge gives a verdict the other way from what the jury decided. So the jury can say guilty, and the judge says there's insufficient evidence under the law. You cannot convict. One or more of the elements of the crime have not been established. I'm directing a verdict in favor of the defendant. Case dismissed.
Override the power of the jury, in other words?
That only
They
goes,
can because if they
importantly,
right
that
if they
only goes one direction, by the way. That doesn't go the other way.
right. It
The
doesn't
judge
go
can't
you're
convict.
correct. It doesn't go the other way.
Yeah.
They can override, the judge can be asked to do what's called a directed verdict. And that's if you find, right. So, anyway, that's the way the judge can be a part of that and making sure that it's not just that non-lawyers are deciding what the law should be and ruling that way. If we had
We
that,
don't
I think we'd have chaos because we
we
wouldn't
don't see
know how
there's
people are
something
going to decide things from day to day.
we don't see there's something wrong with this. The jury's decision is supposed to be final, and the judge can step in and he can
no,
override the decision of
this
the
is where
jury.
the idea is you're supposed to be innocent till proven guilty, and if a judge feels like you were not treated as innocent until proven guilty, it's about saving someone from being criminally prosecuted or criminally punished, even though there wasn't enough
Barely.
counts to. So it's only about defending people from crime, if I'm not mistaken.
Yeah,
Yeah,
that's right.
and also you can have, this is what we do all the time is before a trial, if there are undisputed facts one can make a motion for the judge to make a decision on those legal issues because the facts are not in dispute. So you don't need a trial. And the judge decides based on the undisputed facts, the parties agree on what the undisputed facts are. If there are any disputed facts, you have to go to a trial on those disputed facts. But if they're undisputed, the judge determines what the law is and applies that to the undisputed facts and makes a decision. That's what's called a summary judgment. And that's before trial. And that's very often done as well.
In a different vein, I'm curious about something that it seems, I'm wondering if the dockets in the court are going to explode because of some of the rulings. Like, for instance, there was a recent ruling that they were restricting what federal judges could do, like pause certain things. And
are you talking about injunctions?
Yeah, injunctions.
Yeah.
And then there was this other ruling, I don't know if it was a year or two ago, where Supreme Court said that the certain agencies couldn't interpret statutes that they create.
Oh, okay, those are
which
two
would
different
seem,
things, right?
Yeah,
And so
I know, but
yeah,
my question
sure.
was,
Yeah.
with all these rulings, are the dockets on the lower courts and the Supreme Court just going to explode?
That's what we anticipate, because it used to be that you would just rely on an agency's interpretation of the law, and deference would be given to that by the courts. And what the court is now saying, well, we can decide for ourselves what we think the law is. We're not going to defer to the agency's interpretation of its law and statute and its regulations. So it's called the Chevron doctrine. And for decades, that was relied upon as a basis for the courts to give deference, because they have the expertise developed with so many different kinds of cases within their own sphere that they're deferring to their judgment when it comes to that. And the court said, we're no longer going to follow that rule. We're going to say that courts are allowed to make the determination themselves de novo and not necessarily give any deference to what the agency said. With regard to injunctions, the court was saying is that sometimes people seek a nationwide injunction with respect to a limited number of parties, and the courts are saying, at least the court is saying, okay, with respect to the parties that were dealt with in this dispute, the injunction stands, that we cannot impose an injunction against all parties where the parties were not a party of the litigation. And so there are instances where a nationwide injunction may be imposed, but that was limited by that decision.
Thank you.
So these are great questions, because these are things that lawyers have to struggle with all the time too in their practice, and try to explain to themselves and then their clients, and then try to apply it when they go to court. These are not easy concepts to grasp with. We spend how do you say, semesters talking about these issues.
Wait, anyone
And,
have?
and let me just say too, as someone who has taught law, I appreciate the questions that are coming. They're substantive, they're thought out, they're carefully thought through. I appreciate that. So good
I
questions.
appreciate you coming to be able to answer them, Stephen. So thank you so much for being here.
Sure.
Thank you, Stephen.
You're welcome.
You know, it's okay to
Go ahead.
share something else? Okay.
Yeah.
Sure.
So I need about 5 seconds to bring it up on my phone.
I'm sorry, Sarah, you're saying severe ADHD with this stuff. I know it's overwhelming to me too sometimes. I totally get it. It's like, what?
Okay.
Our heads blow up when we see this stuff sometimes. So you're not alone.
Okay, so I encountered this on right, I suppose, Stephen, you're familiar with I'll call it the book of the court. Maybe you can get a better word. I'm kind of trying to hurry to kind of
Sure, take your time.
give it some sort of a
book
put it
of
in
the
some
court,
sort of a category. Maybe you can do better. It's the Corpus Juris Jucundum. That's you're familiar with that one.
It's a secondary source for looking up law.
Okay.
Right. Yeah.
All right. It says there that a lawyer has a dual role.
Mm-hmm.
and it's the role is one to his client, and then the
Right.
one to the court
That's
and
correct.
to the government. His
Not
duty,
the government, to the court, because we are officers
okay,
of the court
but
and
all
we
right,
have clients that
but
we
it
have
said
to.
the government also. It says the court being the part of the government. So it
That's
says
the
court
arm of the
slash
government, if
government.
you will. Right. Like
Okay,
my duty
all
doesn't
right,
run to the
all right,
agency, it runs to the court.
all right. And then it says his first obligation is to the court slash government. And then after that, it says, so this the lawyer's obligation. And then after that, it says that if they conflict, if his duties conflict, he has to give deference to between the client and the
And the
court
court
slash
system,
government. He
right.
has to give his deference, his I'll
Well,
say he has to give his, I'll say deference. I don't have a good word here. First to the court and to the government over the client if there's conflict between
well,
what the
here's
client,
right.
the
And so let me try.
clients, and
These are
just
great questions. Yeah.
just a little
Sure, go
more here.
ahead. Yeah, I'm trying to I'll go ahead.
And then the definition of so then after that, what follows relevantly here, they define the client as a ward of the court, and a court, the ward of the court, a ward of the court is an infant or a person of unsound mind. That's what I encountered here in this legal book
Okay. All
of
right. So
laws.
let me, if I may
You
respond.
heard about all this already, I suppose.
Yeah, I've heard of these things. And so let me try
Okay,
to take them one at a time. So, yes, a lawyer has duties that run to their client. And
but the
but
court
and
first,
but you
government.
also have duties to the court as a court officer. And so
Okay,
if you, for example, if you're aware of facts that are harmful to your side, you have to disclose them. If you're aware of court cases or statutes that aren't helpful to your side, you still have to reveal them to the court because you're, as an officer of the court, you have to give the court, the judge, everything that the judge needs to make that decision. You can't just withhold information or things on the law that are not favorable to your client. On the other hand, you have a duty not to disclose things between your clients to the court that are privileged conversations. So if the client is asking me questions about the law and I'm giving them advice on the law and how to proceed, that's protected by the attorney-client privilege. I cannot be compelled to disclose that to the court or anybody else. If I'm preparing something in anticipation of litigation, that's my work product and I don't have to turn that over to anybody. And that's not the client's privilege to waive. It's my product and I own it. And so it's up to me whether I want to turn over that product or not. And once it's published or filed with the court, then it's no longer a work product because it's not confidential. So there are a number of things that go into that. So I'm going to try to represent my client as zealously as I can and make the best argument I can based on the law and the facts. All right. And we can have discussions about that all day long. But if I'm aware of something that means that the judge has to rule against my client, then I have to bring that up. I cannot just withhold it and not give it to the other side and to the judge and pretend it doesn't exist. That would be a violation of my duty to the court.
Thanks for clarifying that, Stephen. I have a question for the people that were dubious about the statistics I gave. I want to share my screen again and try to listen to understand the perspective of someone who thinks that there's other explanations. I'd love to know what those explanations are. If on self-reporting, Black people and white people say that they commit crimes the same time, the same amount, and if anything, well, let's say if just keep it at that. If they say they commit crimes of the same amount, and yet Black people are four times as likely to end up in jail, How do you explain that? What's the other explanation that I'm missing that would explain those two facts together?
Well, I would just simply say, Garrett, that you're taking one percentage and you're reaching a conclusion without taking into consideration that there might be other factors involved.
Yeah, so
That's
I'm asking
yeah,
what the other
right.
factors are. That's what I'm asking.
Well,
What
you're
factors would
taking a
explain?
percentage and you're just coming to a conclusion without looking at any other fact.
No, I'm not coming to any conclusion. I'm asking what is the explanation for black people being 4 times as likely to end up in jail if self-reporting says they cause
Then you
crimes
look
less
at the
often?
evidence for how that was determined. You look at how they gathered that information. What was the basis for that? I mean, this is what we do all the time. We don't just say it must be unfair because it looks unfair. You have to look at
Right,
evidence. You can't just
this
reach a
isn't my
conclude.
research, Stephen. This is by, the Brenner
Right. And I'm sure what they did is they conducted studies and they gathered information and it was based on that. You taking a percentage and say that must be true, that the conclusion must be true. That's not evidence. That's just a percentage. It doesn't mean that means that the entire system is corrupt.
what I'm trying to look for is what's the explanation? What's the explanation for why black people are 4 times as likely to be in jail when they are equally likely to commit crimes? Help me understand
Your
what I'm
premise
Right.
missing.
is incorrect. Your premise that they're equally as likely to commit a crime is completely incorrect.
Well, if by
Uh,
self-reporting, are you saying the self-reporting was completely inaccurate?
well, I don't know what that. I'm very dubious of that statistic you
That there,
posted.
there
I
can be
don't.
other, go
I
ahead. Sorry.
considering the culture of the city black community is entirely pro-criminal activity, entirely based on hating the police. I mean, this rhetoric is
How
everywhere.
many people do
Well,
you know?
hold on.
Let Paul finish and then I'd like
Yeah,
to
I
speak. Go
think
ahead.
I
Yeah,
think
yeah,
you need to
yeah.
take into account the severity of the difference. You can listen to country music all day long, but you're not going to be hearing songs about killing the police or raping women or committing drug crimes or violent crimes. It is in their culture. It's hard in their culture, and you can see evidence of it everywhere. There's a book out, and it's a list even. So you can argue that culturally the black community and the white community and the Asian community and the Hispanic community, you can argue that they have the same level of praising criminality. But I think you must realize that can't be true because they're so
Right.
blatant about it in
Paul,
all the media and rhetoric and everything else that comes out.
Paul, I wrote my doctoral dissertation on cultural protectionism in international law, and I can get into this at length with you, but let me try to take it a different way. There could be other reasons why crime is high in certain places and not in other places. The fact that we have cashless bail and there's no accountability for those who are committing crimes, and as soon as they are arraigned, they are released and they go out and commit more crimes. That can account for higher rates uh, in a certain place. If you're not holding people accountable, they say, all right, there's no accountability. I can commit crimes as much as I like. All right. So there could be a number of factors. It's not just socioeconomic, it's not just racial. It could be cultural. It could be other factors that go into why people commit crimes and why you might have a higher rate of people being prosecuted and incarcerated. We don't want to just take a number and say, oh, that's unfair. And so we have to look at the underlying causes for that and address that. And so I agree. It's more of a methodology approach. You're saying it must be unfair because there's inequality, but there may be other reasons. There may be reasons to explain that inequality. And we, as social scientists, need to understand what explains that inequality so we can better address it, not just say in a vacuum, let's have equal parity regardless. And we can make that happen. It won't necessarily be for the social good. We're just achieving an outcome without really achieving a just result.
I still haven't heard. So you're saying if I'm trying to hear what you're saying, Stephen. So you're saying white collar crime that happens more amongst white people might be the explanation being
I never said that. I
Okay.
never said
So
that.
then
I'm
help me
saying there may be
understand.
I'm saying that race cannot be and is not the sole reason for people committing crimes.
No one's saying
And
it's
there may
all
be other reasons for you having disparities. Let's
right.
just not leap at the conclusion that it's solely about race.
No,
Is
but
yeah.
doesn't it bear an answer to say that if
It's it's
self-reported
worth looking at for that basis. We shouldn't assume that that's the reason if we have these disparities. We need to look at the underlying causes of this disparity.
right. So what type of research are you aware of looking into that since
I
the
have not done any such research. I'm not in the field of criminal law. If
okay.
others have that, great. I mean, the Brennan Center is a good place to start. I would want to look at the studies that they've done, look at the methodologies that they used, what evidence that they collect. When you're giving me a percentage and then a conclusion, you're depriving me of everything else that went into
No, I
what you
have all the
presented.
sources. I have all
It
the
wasn't
sources.
meant that it didn't mean that you were trying to
I
deprive us from that, but I don't have that
All the
information,
sources.
and
I
so
have
I'm
all the
not just going to
sources, and I'm happy
agree.
to show the
I
presentation,
agree.
all the sources
Yeah,
of it.
yeah. And so
I,
we as lawyers are going to look at all the evidence, not just one single aspect that might
Uh,
drive a person's decision.
can I?
Garrett,
I'm
you're,
sorry.
but you're saying though that it looks like it's prejudiced, biased against the black people. I
I
think
never
that's
said
not
that,
being,
by the way.
no,
I
no,
just
no, no,
said,
no, 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 no,
yeah,
no.
but it looks
Let
like
him
it.
finish.
I'm
Yeah.
saying that, I'm trying to, how can
Yeah,
I say, it doesn't seem like you're being understood. That's why I'm
correct.
trying to,
Okay.
it looks like they're making it biased, prejudiced against the black people, where you're saying it shouldn't be that way.
Right. I'm saying that
Okay, okay,
if you do research that says like across races and sexes, people are just as likely to commit similar crimes, then
yes,
theoretically if we have a fair justice system, we should have similar representation in jail because people are equally likely to commit crimes of equal severity. So theoretically, we should have equal percentages in jail, but we don't see that. We see not a small
yes.
disparity, not 13% that someone said before. We see four times as likely to be in jail for black people versus white people.
But Garrett, the sentencing disparity is only 13%. What you're talking about is the raw numbers of people convicted of crimes are is a
Talking human
factor of
beings
four.
in
Well,
jail.
hold on. Let me finish my point. Does it seem reasonable to you that there's such huge bias that you have an out of whack number of 4 to 1, but when it gets down to sentencing, it's only 13%?
What is only 13% in sentencing?
The sentencing disparity. You posted it yourself. It's right on page. Black males, 13.4% longer sentences
That's a
than white
longer
males.
sentence. That doesn't mean that we're sentenced. That was length of sentence, not how many people were sentenced.
Okay, but
And it shows,
my point is, how do you have a system that is so overwhelmingly biased against black people that now I think the system has nothing to do with it, but where you can have a 4 to 1 ratio, an extreme ratio of people being arrested, black versus white, and then when it gets into the system and you start sentencing these people, it's only 13%. That doesn't seem plausible to me. When you have a white person and a
you're
black
not
person.
interpreting. What do you think the 13% is?
I think it's a sentencing disparity based on a number of things. Some of it might be racism.
No,
Some
but
of
it's
it might
length.
be what I talked. Well, wait, you asked me a question. Some
You,
of it might be the attitude of a black person being on trial and telling the court that he hates the police. Because again, a lot of times, especially in the media, especially in the all the music and stuff they talk about, the podcast, you name it, they say, yeah, fight the police. You know, they're evil. Defund the police. Hate the police. That's part of the culture.
so
All
one
right.
of the police officers in my grandparents' hometown murdered someone and then tried to hide it because he was a police officer. So sometimes there are reasons to hate the police. The police are not always right. So I understand where some of the frustration comes from. Hopefully you do too. But my point was that the 13% is only in length of sentence, not
Right.
the percentage of people sentenced. What we see by the jail population is that there are four times as many black people in jail. So my
Okay.
question
How
to
can those
you,
two
my
numbers
question, hold on,
coexist?
hold on. You want me to, you want to
All right.
Right.
Go ahead.
let you
Okay.
finish. you can let me finish too. So my question to you is, how do you explain 4 times as many black people in jail when the number of crimes being committed is equal across race and the sentences are only 13% longer for black people?
I don't buy the premise that they commit crimes in equal numbers to be plausible at all. I think it's completely impossible.
Can you give me the statistics that you have to back that up? Because I have
Well,
statistics
I
that
don't
back
even know
my
the
side up.
statistics you have to back up your primary assertion.
They're in the presentation. They're
Well, no, I don't have any links to anything. I have
it's
raw
in
Yeah,
the
you're
numbers.
not,
it's
you
in
don't
the
cite any
it's in
sources.
the notes. If you look up one of the slides has my whole like I did research on this on using ChatGPT for different statistics and all the notes of every
All right, and
source
let me
are
just
listed in
interject, Garrett.
ChatGPT's
The fact that you
history.
let me interject here, Garrett.
Sure.
Um, Whenever you're writing a research paper, whether it's high school level or law school level or whatever, the fact that you use ChatGPT is not a primary source or even a secondary source.
It gives all the primary sources,
No,
Stephen.
all right, all right.
I
You
use
just what
I
you
ChatGPT
just
as a
said is
want
that
to
you
research
say
started from
something.
mechanism.
ChatGPT.
Stephen,
Please.
All
Stephen,
right, but
just
if you
listen,
have to cite the
listen.
specific
Garrett,
sources, right?
Stephen, listen, I use ChatGPT as a web search mechanism to find other sources. All the sources, all the primary sources are listed in the ChatGPT conversation. So again, you are not, I am an AI expert. I've been doing AI algorithms since 2001 professionally for
That
Fortune 500 companies.
that's
I know
fine. All
AI
I'm saying is
effectively.
the assertion that you rely on ChatGPT
Do you
on
rely on
its own
Google?
is not
Do,
evidence.
do you rely on
And we have
Google?
to, and we, when we consider your arguments, need to have access to what it is that you actually looked at.
And
Yeah.
it's in the source, in the
Right.
notes. It's there.
And
I'm
that's
not
fine. I'm
finding
just
links or
saying
any source at
a
all. I'm
general
sorry.
Go to
assertion to the
slide. I'll
use of
find the slide for you.
ChatGPT or that you relied on a report from the Brennan Center, which provides, some, analysis and conclusions, doesn't necessarily mean that that's a primary source. The primary source would be what's contained in that report that they relied upon.
So
And
trace it back.
every case,
I want to
let me
know.
finish. Let me finish. Every legal case is driven by the facts of that particular case.
Slide.
And even when there is a class action lawsuit, and I deal with these all the time, you plaintiffs try to make a general assertion about what's true overall, but then you have to look at each case individually and say, all right, how was that arrived at? And each case is different. And in order to have a class action, you have to have something where everyone is treated exactly the same way for you to have a class, right? And if each case is different, each person is different, driven by different facts for each one, you cannot have a class. And what you're trying to do is say, all right, these numbers I got from the Brennan Center, they must be true. These are, but we haven't looked at them. We haven't looked at what the facts are. And
You're welcome to. You're welcome to. And then we
we
continue
can,
the chat.
but
We continue the chat
what would be really
in
helpful is if we actually had a chance to look at these facts as well. All right, so just to point out to you, this is what we do all the time. We exchange information with each other. We explore different arguments with each other. This is what lawyers do. We don't just say, Garrett, you know what? Because you looked at it and you're telling me it's true, I believe you.
I'm not
If you were
expecting
my
you to.
lawyer, I
I
might
never
believe you,
asked you
but I
to.
don't know this because I haven't looked at
I
anything that
agree.
you've shared
Stephen,
with us today.
I
Stephen, I
agree.
never
Right.
asked you. I never asked you for blind faith. I gave you all of the details, and you're welcome to scrutinize them to your
Right.
heart's delight. But
And that's
please,
fine. And what I'm saying is we
please,
cannot
please,
agree with
please,
you
Please.
tonight
let
on
me
that.
finish
When
Right.
do I
speaking,
get to talk?
please.
I'm sorry, Devin, go ahead. Right.
I mean, I agree. Like, I don't want to say the status is correct, but like, I need to know how they got it.
Guys,
It's
all the
misleading.
sources
Right.
are
So do
there.
I.
All the
I
Right.
need
sources
to
are there.
know.
Go to
I need
slide
to know.
4.
No, I need to know where they got it. They could
So
just
you
grab
can
any
trace it
information from
back.
anywhere.
You can
Right.
trace it back. You can trace it back. Please. It's after 9 o'clock. It's 9:10. I have to put my kids to bed. All the
Mhm.
sources are there. They're in slide 4, the entire conversation, and all the sources are in the conversation. All the sources, and you can
Right.
go back to the prior source, to the prior source. down to the actual legal cases and down to the actual studies that were run, they're all there. So go through them. And then after you go through them, come back to me and I will buy drinks and dinner and drinks for anyone in New York City that can prove me a good reason that black people are 4 times
All right.
likely to be in jail rather than that there's bias in the system in some way, shape, or form.
Okay.
You have to give me a
Well,
better explanation, a plausible explanation, other than that there's bias in the system. So
I
that said,
still
I'm
don't
going to
have
close.
your I
No, no,
still
no.
don't have your data. And I'm looking at
Closing out. I'm going
slide
to give the
four.
last word on
I
this
don't
one.
see anything.
Paul's
It's
looking at the
this
presentation. He's not
entire
seeing your
chat
data.
GPT conversation. I'll put it in the chat. Copy it now. It's on slide 4, exactly where I
Yeah.
told you it was. And I will put it in the chat for you because apparently we're not all so good at chat at using slide sources. So this is the entire ChatGPT conversation. I did do research outside of that, but that's the one that has the sources for the things in the
Right.
slides.
Right.
Thank you, Garrett, and good night. Thank you so much. Thank you
Yeah.
for what
Thank
you've
you,
done.
everybody. Appreciate it. And I'm
Okay.
sorry I'm frustrated, but I have
Mhm.
three
You're
people
not.
talking over me and saying that all the sources that I've been completely transparent about are not being transparent. I've been nothing but transparent, and I'm happy to continue to be, but I want to hear your explanations as to what the alternative explanation is after you go through the sources. So I hope you all have a
And
great night.
Garrett, what I'm telling you is
Okay.
this is what I do for a living every single day.
AI is
And
what
this
I
is
do
why we
for a living,
disagree with
Stephen.
opposing counsel every single day.
Yep.
They might have their sources,
Thank
we will have
you.
ours. And we don't just look at something for a minute and say, I agree with
Yeah, I'm
you.
giving you time,
We
Stephen.
look up our own sources and try to
I
figure out
want you
what the
to.
truth is.
Look up
And
your own
that's all I'm saying. I'm
sources.
not saying you're wrong. I'm
Yep.
saying I can't agree with you right
You
now
don't have
because I
to.
haven't looked at any of these
I'm
sources.
not asking you to agree with me at
And
all.
I'm not, and
I want to
frankly, I don't have
say,
the time to go through everything that's cited in a Brennan report because that's not my job. My job is to represent the city of New York. And starting tomorrow morning, I will resume that job.
Yep.
But this is what lawyers do, and this is why we have disagreements, and this is why you need a legal system that doesn't just rely on AI to
We also
generate
need a
the
legal
outcome.
system that doesn't put 4 times as many black people in jail just because, even though they're
And
just
you
as likely.
don't know that that's the sole reason why they're in jail. You don't know that,
Again,
Garrett. You don't know that. And that's the
I'm looking
point.
forward to your
You
alternative
don't know. I
hypothesis.
don't need to. This is what trials are for, Garrett. You don't just leap to conclusions because you like the outcome.
All
You
right.
need to
So
have a
I hope
trial,
everybody
and
has
that's
a
what the
great
system
night.
is for.
Good
I hope
night.
everybody has a great night. Thank you all for your time. Thank you, Stephen. I
Okay.
appreciate your expertise.
thank you so
Good
much,
night.
Dr.
Thank you.
Stephen.
Bye-bye.
Take care, everyone. Bye bye.
Good night.